Court calls the case People versus Lawrence Buckner.
That's one people.
Right, the assistant public defender on behalf of Mr. Buckner.
Your name, sir? All right.
Your Honor, so, obviously we're here for our college conference. I have a chance to speak to the prosecutor, Mr. Buckner. I think we'd like to set this matter for further examination.
All right.
There's currently two steps for April 20th for the accommodate that date.
April 20th,
22nd.
22nd. Who are those before?
Just one.
Okay, the 22nd is the date I'd give in any event. Those are set already before.
Yeah,
Okay.
There's one. I don't want it. The other one is Mr. Johnson's case.
They are.
I believe it's all the boxes.
They're both set. With Washington. People don't have any objection to that.
No, we'll try for that date, Your Honor.
All right. Preliminary examination in person, April 22nd, 2025, 9 a.m. before Judge Washington. You may.
Yeah, Mr. Buckner's here. He's not a flight risk in any way. Locally, I believe that the objectives of the court could be accomplished in terms of any violation or any kind of contact with any of the confirmed witnesses in these matters. Could be achieved through a tether or a hot zone or a tube zone. As I said, he's not a flight risk. He has a bond. I believe the bond in this matter is $75,000. In looking at it, I think there's a bond of remand in the MDOP case, which is not the case I'm representing him on. But I'm not quite sure if that was
There's two other cases. What do you have as this one? Because I don't have those before me. So.
if I don't. I need to address the bond
Well,
in the case.
Mr. Buckner was going to try to say something, but I don't know if you want him to say anything, Mr. Betty.
Judge SImpson, last time I was in court, I came here to go to court. Prosecution had brought up intimidating witness charge. You said that you were going to remand me back to the Washington County Jail until you get that video to see if I actually threatened witness.
Well, until right, but let me just clarify that. I was going to look at it as to whether or not I was going to do a remand prior to the charges coming forward. The problem was the charges then came forward, and so I arraigned you on the charges. So there was a distinction in what I was doing at that point, but go ahead.
I was under the impression that once you look at the video and see that any criminal activity was done on my part, that you would reinstate my bond. In my words, watching the videos, I didn't do anything. It's he say, she say. I wasn't going to be in crime, sir.
Okay, so Mr. Buckner, just so you understand what I was doing. Remember at the time that you appeared here, and a flight risk is not my issue with Mr. Buckner at all, because he voluntarily came in and he cooperated with the court in every respect whatsoever. But at the point at which we were addressing it and it was brought up to the court, I did not have a complaint in the case. And so what I was doing, the people at that point were asking to have you remanded, defense counsel, and you were objecting to that. And at that point, I was going to make a decision as to whether or not I was going to remand with knowing that the charges may be coming. But I wanted to look at something because you were vehement in saying no, people, and I knew that there was this video there. Before I could even get to that, the charges came through. And so then at that point, you were arraigned on the charges themselves. So there was at least some determination, although minimal, that the actions occurred because the charges had come forward. Okay.
Judge Simpson, I would like to say in closing, I appreciate you. However, I was brought back up.
Thank you.
To see you at 3 p.m. And informed me that you didn't get to watch the video, but you did.
I know. Okay, so we can go, Mr. Buckner, we can go through all of this. The problem is, it doesn't matter what the bond in this case is because he's denied on his other case. So I'm not going to change everything, let it all get before Judge Washington. She can make a determination of your bond. She can hear this argument of the bond in this case, as well as what's going to have to be your argument in the other case. Because I could change your bond in this one, it doesn't release you.
I'm talking about the $75,000 bond. I'm talking about the bond. I came to court for I was at the court for the gun charge, no, the NDOP case. They told me, you know, it is what it is. Yahweh, God of the universe will vindicate me, and I'm thankful for all this time. Thank you for the time.
All right.
You know, we get to 2 weeks in jail, time to sit there. And, no weapon formed against you prosper. In these lies, I will be vindicated. I will be vindicated. And I hope, and I will be filing malicious prosecution against Washington County for everything that they did to me since my shooting.
All right. So what I'm going to do is I'm going to deny, just so that we have a record of it, I'm going to deny your request. The reason I'm denying it is because he's held on the other matter. And then this exam will be set on the 22nd with all his other matters before Judge Washington. Bond will continue in this.
Thank you, Your Honor.
Thank you. Hey, Mr. Gardner, that's where the problem comes in. Just walk out quietly or go out quietly, please. I've been that for 60 some odd years. I get it. I don't know. I was just focusing on the whole hard to be or whatever. And I was going to ask Feaster and Lauren for their opinion. Oh, okay. All right. I'm just asking. All right. I didn't know. Court does call the cases of the people versus Matthew Fitzgerald, 2 cases.
And good morning, Your Honor. Robert Allen, on behalf of Fitzgerald, in case 507.
Okay, where's my second ruling? Oh, no, saunter up. We'll wait.
Your Honor, I want to start by thanking you for passing this case earlier, allowing us this time.
All right. Have you seen the community corrections violation report?
Yes, we have, Your Honor.
You're doing on this today.
Your Honor, as far as my case itself, I'm asking for an adjournment. I was disappointed yesterday, and there'll be time to obtain discovery. If you'd like us to address the violation, we can go right into that.
Go ahead.
So, Your Honor, the test on April 2nd was my client's first test. He also has a case out of Livonia that he actually tested for yesterday and tested clean. He says that he will test clean today.
Do you have those results?
We do not, Your Honor. I didn't have an opportunity to call Livonia. It's on-site substance abuse testing here in Washington County. We can absolutely reach out to them. He states that he did not sign a release of information, but it seems like he was confused, Your Honor, because of his testing obligations in the Livonia matter. He didn't realize that he would have to be simultaneously testing. I told him that he could sign a release.
How long has he been testing in Livonia?
That was my second week.
What was your second week?
Yesterday. Yes, second test.
I have his arraignment date is March 31st. I have a test on April 2nd with a report on April 9th that he's positive. He was instructed at the time of arraignment he's not supposed to be using drugs. He's positive for fentanyl, cocaine, opiates, and amphetamine.
Your Honor,
Also, as I'm to understand that at the time he tests positive for these, he's also not supposed to be using narcotics from his order out of Livonia. So you'll be in violation in that case also. Go ahead, you wanted to say, Mr. Allen.
well, Your Honor, I think with his arraignment on the 31st, I do know I'm not a scientist, but we know that sometimes it takes some time for drugs to get through the human body and out of the system. And as I said,
Is he gonna tell me that that he did not use after the 31st?
he says he did not use after the 31st. Again, the positive test was on the 2nd.
When did he test in Livonia before that?
I cannot tell you the exact date, but it was around the same time. It's the second.
Your Honor, if it helps to establish the timeline, Mr. Fitzgerald would have been arraigned on his OWY out of Livonia on February 4th of 2025. He then, his next appearance in that case was when he entered the plea on April 1st. I'm assuming that he was transferred there after being arrested on this matter, which obviously occurred the day or two prior to that. And controlled substance possession is obviously one of the charges here.
So what makes me think if he was in violation of Livonia's order, say he's not going to be in violation of mine, because he is in violation of mine. This one.
Your Honor, all I can ask is that you give him a chance to show you that he can follow your order.
And Judge, I'd like to add also that, if we can, I don't know what the conditions, for his Livonia case would be, especially now that he has entered a plea. But I know that here, obviously, we've got outpatient treatment, we've got CCOP, we've got some inpatient options. Clearly, substance abuse is an issue at this point. He says that he has been trying his best. He reports that he would be clean today. We don't have the results from the other test yesterday, but hopefully those are also negative for any substances, Judge. So we ask that he could at least have the opportunity to get an evaluation or assessment to see if we can get him for the treatment program.
Anything else you want to say?
No, Your Honor, just that you give him a chance. Like I said, he can, like co-counsel has said.
Well, let's do this. You can get a release from him. I want those Livonia results because something's not quite adding up. He's, and it's not like it's one drug. He's got a whole cocktail in him when he comes here to testify or comes here to test. So I'll adjourn his probable cause conference to next week, the 17th, 2025 at 9 a.m. And I'll just say this, I also am not believing, given the basically shelf life of some of the drugs in his system, that he didn't use after I am not convinced that he didn't use after he was arraigned. So at this time, defendant's bond is revoked, and you guys can get a release of information from him and make a determination as to getting those test results to me, and I'll take another look at it.